You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20.
Right out of the gate, the judge drops the bomb. Aggravated assault with a deadly weapon. That's not just serious, that's life-altering. In legal terms, a second-degree felony means the court has a wide sentencing window, from 2 to 20 years.
Your plea. Did you understand?
Yes, ma'am.
Mariano.
Notice how quickly he answers yes, ma'am. This is common in plea hearings. Defendants are terrified of saying the wrong thing. But think about it. How many people actually understand what they're agreeing to in that moment?
If he truly gets a second chance. When your future hangs in the balance, what would you risk for a shot at redemption?
All right. Oh, this is Mariano Rendon Jr.
Yes, Judge, I've filed notice of appearance as additional counsel. Mr. Blucas is aware. He was anxious to accept the plea agreement as the state had offered him. Larry's in trial in Comal, and so I'm just here to, well, I'm new on the case, but we want to delay the process with doing the substitution. So he just let me do the additional counsel notice.
So in the indictment, it has him down as Mariano Rendon, but then in all the plea paperwork, it says Mariano Rendon Jr. Is he a junior?
Yes.
Okay. All right, the court is calling 2024 CR 2339B, State versus Mariano Rendon Diaz. I'm sorry, Mariano Diaz Rendon Jr. Do I have parties announced?
Raymond Martinez for Mr. Rendon.
Here's the twist most viewers miss. He's going to serve prison time first, then come out on probation. That's like finishing the punishment only to start another one. Legally, this is called deferred adjudication, meaning the court holds the guilty.
Earlier this week, I explained to him he would be set today, and he related he didn't know when he could come in to do the plea because he's in trial in Comal and it may go into next week.
All right. Counsel, have you received all discovery?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Rendon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Rendon, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
All right, off the record for a moment. So he was sentenced in another case, correct?
Right.
So,
Same incident, different charge.
all right, so in that case, he received prison time?
Yes,
So he wants to be in prison, then come out on deferred?
that's the offer the state's making. He wants to close out his case. He doesn't want to stay here waiting to try another case. This is the same offer the co-defendants have received. He's okay with it. He wants to go serve his time, and then he's willing to do the probation.
So how much time did he do, how much time did he receive?
Listen closely. By entering this plea, he gives up 3 huge rights: jury trial, cross-examination, and the right to remain silent. Once you say yes here, there's no rewind button. Would you have taken that risk?
Did you review that? I'm sorry. Oh, we're still. All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I give you all.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's an affirmative finding of deadly weapon. The state recommends deferred adjudication. There's to be no contact with the complaining witness, anger management, MRT, and TAP. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be 200 hours community service restitution, no contact with the complaining witness, and a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
No objection, Your
All
Honor.
right, state, you may be excused. Did you review the waiving stipulations with your
Listen closely. By entering this plea, he gives up 3 huge rights: jury trial, cross-examination, and the right to remain silent. Once you say yes here, there's no rewind button. Would you have taken that risk?
You understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments. All right, we're back on the record in 2024 CR 2339B, State versus Mariano Rendon. The defendant had entered a plea of no contest. State, are you offering State's Exhibits 1 and attachments?
Yes.
No objection?
No objection, Judge. We did look at them.
All right, and again, Mr. Rendon, you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient.
This moment right here is the judge's reality check. Freedom isn't freedom unless he follows every rule perfectly. It's not just a second chance, it's a test, and the stakes couldn't be higher.
Understanding that you do not wish to be present for a restitution hearing. Is that correct, Mr. Rendon?
Actually, Judge, I confused the court. That's on his other case that he's already been sentenced on, that had a post-conviction restitution hearing pending.
All right, what is the cause number for that case?
His cause numbers 2024 CR 2338B.
All right. Mr. Rendon, in cause number 2024 CR 2338B, are you asking to waive your appearance for any restitution hearing in that cause number?
Yes, Your Honor.
All right, and defense, have you spoken to your client about his waiver of the appearance at the restitution hearing?
Yes, Judge, and while we were off the record, I confirmed with counsel. It looks like they have a general idea what the number is going to be, and I've shared that with Mr. Rendon, so he definitely would like to waive his appearance.
Right. And in regards to the instant case, is there anything you wish to say on behalf of your client?
We just asked the court to follow the plea agreement, Judge.
All right, state, you may be excused. The court will sentence you to 5 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 60 days. Well, I'm going to say proof of employment within 90 days of release because I know you'll be in custody. There's to be no employment as a home health care provider or with minors or in the bar industry. There's to be no contact with Oscar Del
Hero,
Fiero,
hero,
Fiero,
hero.
Fiero. There's to be anger management.
Mariano.
TAP evaluation. 200 hours of community service restitution. 100 hours will be waived upon completion of anger management. Field visits 1 time per month for 8 months. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Oh, I'm so sorry. There's also an affirmative finding of deadly weapon. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. When you're released, we can go off the record. People always forget this. That is why when I was a defense attorney, I never liked for judges to have somebody go to prison, then you come back out and you're on probation. So you need to remember, when you're released from prison, you need to report to probation on the first business day of your release. You understand?
Yes, Your Honor.
If you don't do that, there's going to be a motion to revoke file.
Yes, Your Honor.
And probation will give you information on who you should contact.
Yes, Your
And if you don't remember, if I'm still here when you're released, come and check in here and they'll give you information, okay?
Honor. That's gonna be on the same day, correct, Your Honor?
Yes,
The day after you get out. Or the
Yeah.
day?
yes, just the next business day, okay?
Yes, Your Honor.
All right, good luck to you.
Yes, Your Honor.
Thank you.
Diaz didn't walk out free. He faces years in prison, then careful probation. But will strict second chances work, or is this just more punishment? Is it fair for justice to stretch beyond the cell? Would you have taken the deal or fought for a trial? Let us know below. What would your verdict be?